Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about an absolutely wild development in the Delphi murders case, also known as the state of Indiana versus Richard Allen. The defense team has alleged that critical evidence, or potentially critical evidence, has been destroyed, and they're asking for the case to be thrown out. So let's go through the documents, and I'll talk about those, and I'll talk about what this might mean. Okay. So, motion to dismiss for destroying exculpatory evidence. It says, comes now. I hate that term. If you've watched this channel, you know I really hate that phrasing, but it shows up in all sorts of legal filings. Comes now the accused, Richard Allen, by and through counsel Andrew Baldwin and Bradley Rossi, and pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution, skipping on a little bit, he moves this court to dismiss the charges against the accused for destroying exculpatory evidence, which means evidence that would tend to make it less likely that he committed the crime, evidence that tends to help his acquittal, in violation of the standards set out in Brady v. Maryland. So Brady is the critical case on the prosecution's requirements to turn over evidence to the defense. In fact, Brady violations are one of the key things that it's identified in various wrongful convictions. In support of said motion, the accused states the following. So these are the allegations that are being made. None of this has been proven at this point, but they're not going to be making allegations on nothing, one would hope. So, Richard Allen stands accused of murdering 2 victims on or about February 13th, 2017. Since receiving discovery in this case, the defense has unearthed significant evidence that third parties named Brad Holder and Patrick Westfall were involved in the murders. That evidence is critical to the theory of defense. So we're getting a little view into what they're planning to run as a defense here, which is essentially, our guy didn't do it, Mr. Allen didn't do it, it was these other 2 guys. So this is kind of a rare defense. It's not most common that you see something where they're pointing to a specific other possibility, but that's what we've got here. The defense would incorporate into this motion the contents of a Franks memorandum that was filed with this court on September 18, 2023, which provides the details of the evidence that supports Brad Holder's and Patrick Westfall's involvement in the murders. So I'm not going to go through that in too much detail, but basically they're saying there's evidence that connects these 2. It's not just pure speculation. In discovery, the defense found a document dated February 17, 2017, that appears to be an FBI report memorializing an interview of Brad Holder. Contained within the document are these words. The below is an interview summary. It is not intended to be a verbatim account and does not memorialize all statements made during the interview. Communications by the parties in the interview room were electronically recorded. The recording captures the actual words spoken. So this is a little cautionary note. It says, hey, don't rely on this document. You should, if this matters, go back to the original recording, which is, of course, the gold standard here. Also in discovery, the defense found a document dated February 19, 2017, that appears to memorialize an interview of Patrick Westfall. There's a spelling error there, but no big deal. The report itself does not indicate whether the interview was recorded, although the defense would expect that standard procedure would require video or audio recording of all statements. In fact, I would be shocked if that recording or if that interview was not recorded. Police record basically all of these kinds of interviews because A, recordings are super helpful, and B, typically, that's policy. So after locating this document, the defense sought a copy of the recording detailed in the February 17th, 2017 report so that the defense could listen to the exact spoken words of Brad Holder during his interview. That is vital to Allen's defense, particularly the statements that the author of the document admits were not memorialized in the document. So they want all of the statements that weren't written down, as well as the ones that were. And we're going to talk about the importance of having that recording versus this memorializing document and how little use a memorializing document might be. Also, the defense requested a copy of all audio video of Patrick Westfall's interview that was memorialized in a February 19, 2017 report. On September 8, 2023, the prosecutor communicated in a letter that there were no audio or video interviews of Brad Holder or Patrick Westfall available. Now, available is critical here. It's not they weren't taken, it's just they're not around. What does that mean? Well, he doesn't say. Our prosecutor McClelland offered no explanation as to why these didn't exist. And then before the defense had an opportunity to investigate the reason why these material pieces of evidence were not available, prosecutor McClelland called for the disqualification of attorneys Rossi and Baldwin as Richard Allen's lawyers. Judge Gull, without a great deal of hesitation, said she was leaning toward granting McClelland's request. Ultimately, Judge Gull caused Rossi and Baldwin to be taken off the case. This occurred before Baldwin and Rossi learned of why crucial videotaped interviews were missing. Now, this is some suggestion of shade here of misconduct, but these two lawyers get put back on the case. On January 31st, 2024, after being reinstated to the case, the prosecution turned over discovery to the defense, including a letter cataloging the evidence the prosecutor was turning over to the defense. Contained on page 5, paragraph 5 of the itemization of discovery are these words that explain Brad Holder's missing videotaped interview and Patrick Westfall's missing interview, if one existed. And so this is a quote here, and just keep in mind how you'd feel if you were the accused here. Due to a DVR program error discovered on 9/20/2017, so that's, September? All recordings up to February 20th, 2017 were recorded over. There is no detectable audio found on this drive. Now, the timing on that feels really, really convenient, right? Up to February 20th. Well, the recordings taken on the 17th and the 19th? Remember, Brad Holder and Patrick Westfall were interviewed during this very short window, February 14th to February 20th, within days of the murders. The videotaped interviews were deleted by the police. It is unknown what other interviews were deleted during the relevant timeframes. So maybe there's other videos, but that's purely speculative. The possibility of other interviews is not going to get them anywhere. I can be sure of that, unless they find some evidence of what they were. The destruction of material interviews of key suspects early in the investigation demonstrates negligence, if not intentional conduct on the part of the state. I don't see how they're going to be able to prove intentional conduct. It's going to be a real tough road. If they could, then that's fantastic. Then, at least for the defense, they're in a much better situation. But it's going to be a tough place to get to. How could law enforcement, while investigating the most serious of crimes, record over interviews of material suspects with recklessness or intentionality? You would think that they would want to have backups of this and, preserve it, because this is critical evidence in a double homicide. How does that just go missing? How does that just get deleted? As a material part of his defense, Richard Allen is expected to direct the attention toward Brad Holder and Patrick Westfall as being involved in the murders of these two young victims. The evidence will show that Richard Allen does not know Brad Holder or Patrick Westfall, and therefore that Richard Allen had nothing to do with the murders. It was them. They did it, not me. This destroyed videotaped interview of Holder and of Patrick Westfall, if it ever existed, that's with referring to Westfall, they know there was one for Holder, was expected to contain evidence that could provide exculpatory and material evidence in support of Richard Allen's defense. If a recording of Westfall was never secured, that too is a purposeful or negligent failure to preserve material and exculpatory evidence. I don't think they're going to get anywhere on the failure to record, but I think that they, on the deletion, there's a bit more of an issue. We'll talk about that. Experienced defense lawyers fully understand the significance of comparing and contrasting the accuracy and credibility of one's video audio tape statement with that information which is represented by law enforcement officers in police reports or summaries. What this means is that police reports and summaries often are, how do I put this, not correct. You'll see police say something like, during this interview, the accused confessed. And then you watch the interview and it's like, oh, that never actually happened. Summaries are summaries, and sometimes they are vulnerable to frailties of memory because those summaries might be prepared afterwards. There's all sorts of issues. It is through this process that Richard Allen would have been able to challenge the veracity of the statements of Holder and Westfall. However, the state's intentional or negligent destruction of the original recordings deprived the accused of such an opportunity. Again, I don't see anything in this that says that they'll get to intentional, but negligent seems accurate here, right? Now, this is critical because we're going to run into problems, or they're going to run into problems if they're trying to argue anything based on these summaries. The state's actions have deprived the defense of the ability to compare Brad Holder's words from February 17th, 2017, only 3 days after the victims were murdered, to the evidence that was unearthed over the next several weeks, months, and years. This would have allowed Richard Allen to determine whether Holder's story was consistent with unknown evidence at the time of Holder's first statement, and whether it is consistent or inconsistent with future testimony, be that trial testimony or deposition testimony, or statements made to other persons or witnesses. Essentially, we don't know if he was lying during that. And if he was lying, then that might be a very powerful indicator to a jury that maybe it was this Brad Holder guy. Ultimately, this is going to be a very difficult spot. Maybe he says something that the police accept about, like, this is the route I took home, and later it's determined that no, he didn't take that route. He took some other route. So what was he doing during that time? But you can't actually do much with this summary. Let's say you get him up on the stand and you say, hey, in this summary, it says you did this. Well, he can easily say, okay, cool, that summary's not correct. And what are you going to do? You can't show him his own words in order to impeach him there. All you've got is this summary that doesn't mean anything. In any criminal investigation, the interviews of potential witnesses must be preserved, such as the precise words of Holder and Westfall in their 2017 interviews, because as additional information is developed, reviewing prior statements may reveal inconsistencies or raise questions about other witnesses or other information relevant to an unbiased investigation. I don't think that this is disputable. Without the actual audio video that would provide the exact words spoken from Brad Holder's mouth, the accused Richard Allen will never, ever be able to know exactly how many inconsistencies existed in the original statements of Brad Holder and Patrick Westfall when compared to the evidence that was later discovered or future testimony of Holder and Westfall. So let's say he gets up on the stand, Mr. Holder or Mr. Westfall, and testifies to something that is in direct contradiction to something that was in those videos. That would be extremely relevant, but defense won't be able to know. They won't be able to identify that. Similarly, if they, for instance, let slip some detail that later showed that they had knowledge of something critical when no one else did, well, we won't know. Let's say they told the police something that turns out to be an absolute lie. We won't know. All of this is very concerning. So that's where this comes down to. Furthermore, Allen is deprived of the ability to confront either suspect with their own words, contradicting any self-serving testimony they may offer throughout the investigation or prosecution. Again, if you try to say, hey, you said this during the interview and now you're saying a different thing now, they can easily say, well, that's not what I said during the interview. And how do you prove that? Well, maybe the officer got it wrong in their summary. You'd really want to be able to say, oh, you said this, huh? Here's the videotape of you saying something else. They can't do that now. On August 30th, 2023, following depositions in which the state of Indiana and law enforcement learned that the defense believed Brad Holder to be an actor in the murders, law enforcement finally re-interviewed Holder for what is believed to be the first time since 2017. Now, I'm just going to note, defense lawyers, there's pretty much a rule, which is you don't want your client to be interviewed by the police, but you especially don't want them to be interviewed a second time, because if they give a second interview, there is no way, even an honest person cannot keep their facts together from one interview to another. It's just a failure of memory. And so for the defense perspective, it's very helpful that there was a second interview, but only if you actually have access to the first interview. And they're going to point out some of these inconsistencies. While in 2017, according to the memorialized report, Brad Holder told law enforcement that he never met Abby Williams, who was purportedly dating his son, his story changed in 2023 when he talked to law enforcement. In 2023, Holder told the interview at the 3909 mark, "I barely even knew that girl. I met her once." So now the question is, did you never meet her, or did you meet her once? Which is it? This is the kind of thing you would want to confront somebody with, but you can't now. Therefore, one material and highly relevant contradiction exists. It is therefore plausible that many more contradictions would be available to the defense, but for the state's intentional or negligent failure to preserve all of the evidence. Such negligent and intentional conduct on the part of the police has also resulted in the absence of material evidence which could be exculpatory in nature. This circumstance, in and of itself, violates Richard Allen's due process rights. We must, however, place such conduct in a greater and more noteworthy context. So they're going to give us a bit more detail here. It has also been discovered that former Rushville police officer Todd Click reached out to Prosecutor McClelland in an attempt to bring to his attention the existence of an 85-page report summarizing the investigation that revolved around Brad Holder, Patrick Westfall, and other affiliates. This letter, which landed on Prosecutor McClelland's desk via certified mailing on May 1st, 2023, was not discovered to the defense until more than 4 months later, on September 8th, 2023, and only after the defense disclosed in depositions that they were aware of the odiness tied to the crime scene and investigation. This failure to disclose on the part of the prosecutor, if not entirely intentional, rises to the level of an untimely failure of disclosure of potentially exculpatory evidence. The failure to disclose sheds further suspicion on the absence of the Holder and Westfall interviews referenced herein. So defense is basically trying to suggest some sort of nefarious motives. Like, hey, maybe you knew that there was some issues with your case. There's some muddy water here. There's these other guys who might be a problem, because if you're trying to convict Mr. Allen, you really don't want the possibility that somebody else did it. That might amount to reasonable doubt. And so a lot of Brady violations amount to or arise from prosecutors failing to turn over things because they don't really want their case to be muddy or messy. They want a clear path to a conviction. That's kind of what the defense seems to be trying to suggest is going on here. As opposed to, for instance, just we had a technical oopsie and data went missing. Furthermore, as explained in the Franks memo, it appears as if law enforcement, and possibly the prosecutor himself, attempted to conceal the identity of a Purdue professor who contradicts the sworn words of Trooper Jerry Holman and Sheriff Tony Leggett concerning whether the crime scene contained signs of the involvement of an Odinist cult. Now, when I read this, I just go, an Odinist cult, okay. It's never a cult. But, I mean, maybe, but no. It's just not something that you typically see. People's motivations tend to be a lot more basic. In more recent discovery, defense also located a prepared search warrant application for AT&T for data contained on Brad Holder's and Patrick Westfall's mobile devices. Each application states that Holder Westfall is a known member of a religious sect, and elements of the murder have potential religious significance. The information being requested is relevant to an ongoing criminal investigation. There's no evidence that the warrant was ever served. Now, they're not going to be able to get anything, I don't think, from we had a warrant, but we never pursued it. There isn't like a requirement to collect any particular evidence. So, also, the defense has not located any discovery regarding any data contained on Holder and Westfall's 2017 phones or any other electronic devices. It defies logic that law enforcement would conduct forensic examinations of so many other phones in its investigation, yet ignore the phones of Brad Holder and Patrick Westfall, who were viewed as suspects within 3 days of the murders and interviewed by law enforcement, who then prepared search warrants for those phones. Again, they're trying to suggest some sort of nefarious or cover-up or something else along those lines. These suspicious facts further call into question the circumstances surrounding the destruction of key videotape statements of Holder and Westfall, if it ever existed, and support Richard Allen's motion to dismiss all charges filed by the state of Indiana. Defendant requests a hearing, at which time he can present evidence and make arguments as to why these charges should be dismissed. The defense files contemporaneously herewith his memorandum in support of this motion. Okay, so that's our motion on all of this. Now, I just want to talk a little bit about what this might mean. So I'm not going to go through the full motion and the memorandum today. We went through the motion. I'm not going to go through the memorandum. That's going to be much longer and perhaps something for a live stream or a later video. But let's talk about what they're asking for. They're asking for these cases, or for these charges, to be thrown out entirely, which is a big ask on a double murder, especially a double murder that has captured the public interest. This is a case that has been unsolved since 2017. It's resulted in a lot of media scrutiny. I think a court is going to be very reluctant to throw these charges out. But it does create a bit of a problem, because here there's these potential other suspects, at least according to the defense. And how do we deal with that? Because you can't unring this bell. You can't, unless they somehow find these statements, oh, turns out we made another copy. It just ended up behind the fridge or something. Unless you find another copy, you can't fix this, right? There is no remedy. There is no repairing it. It's just a question of whether or not it's safe to proceed to trial. And I have concerns about proceeding to trial in the face of this kind of missing evidence, because while there's reports that there's been a confession in this case, that's not necessarily determinative. People confess wrongly sometimes. I want to see a full case brought, because as much as people are going to want to see a conviction in this case, we want to see a conviction of the right people. And if it's somebody else, well, that would be concerning. We don't like the idea of somebody getting away with murder, but we might have a problem as to who would that person getting away with murder be. Is it, Mr. Allen, who's charged with it, or might it be these other individuals? We don't know. Right now, again, none of this is proven. All of this is just sort of allegations made by the defense of, we want to explore these issues, but these are big issues. Now, we're going to have some issue, or there are some ways the court can try to sort of work around this. And one of those, there's a case, so State versus Hawkinson, and this is a decision that basically says, listen, unless you can show that the evidence was on its face exculpatory or material, which is of course going to be a debate and a way that the court could say, well, you don't know what was on those things. There's no way to know if these guys are actually suspects. This is all just speculative. Then you might need bad faith. And I don't think that the defense is going to be able to get to bad faith here. They don't have a smoking gun. What this all could be is just police screw-ups, and that's going to be a real problem. There's other cases, Arizona v. Youngblood. I keep wanting to say "and" because I'm Canadian, but that's just the way it is, where in that case some DNA swabs were lost, and because of failure to properly preserve them, and that wasn't found to be a Brady issue. So we have some real issues here, because Brady itself says it shouldn't matter whether there's good faith or bad faith, that we should have fair trials, that the prosecution can't be the architect of an unfair trial, these kinds of statements. But in actual practice, when the rubber hits the road and you have, a double homicide, the courts are going to try to find some way to say, we're not throwing this out. I don't think that the defense is going to get the remedy they want of throwing the case out, which means that they're going to have to run this case without this critical evidence. And you might be okay with that. Lots of people are not big on sort of defense rights, especially on a case like this. But consider the possibility that maybe it was those people. I don't know. You don't know. None of us really knows. And if they can't explore that, then we create the possibility of, maybe somebody else gets away with it. all of this is going to be incredibly troubling. Whatever happens in this case now is going to be concerning, because if he goes to trial and he's convicted, well, would he have been convicted if we had that audio? We don't know. If the case gets thrown out, lots of people are going to be unhappy. Lots of people are going to be unhappy, especially the victims' families will be unhappy. And if he goes to trial and gets acquitted, well, I guess that's the only sort of circumstance that kind of avoids an issue here. But I don't know that that's... We'll have to see. That's not where my money is if this goes to trial as it stands. But let me know in the comments what you think. I myself, and I mean, I'll show my bias here. I'm a defense lawyer. I would be extremely troubled if this was my client and this was the situation we're facing. I would be extremely troubled if it was me. Like, if I'm facing these charges. But, I mean, this is a very emotionally sensitive, complicated case. So let me know what you think. I want to hear your thoughts. Post a comment. I'll try to read through all of them. I may not be able to respond to all of them because there's lots of you guys, but I'll try to give them all a read. So thank you guys for watching. I hope you found this to be interesting or educational. I think this is wild. But please like this video, share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters at the $50 level: CCFR, Canada's National Firearms Association, and the Canadian Shooting Sports Association. At the $20 level, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Drunkle of the Baileys, Cameron Johnson, Andrew Elsich, Vicky, and Dorky Dane. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge. See you next time.